Generally, a plaintiff can recover all damages that are proximately caused by a defendant's negligence, including subsequent aggravations of his or her original injury that are a natural result of the negligence. However, if an unforeseeable intervening act causes the plaintiff's subsequent aggravations, the defendant isn't liable for those injuries. In the 1971 case, Bruckman v. Pena, the Colorado Court of Appeals considered whether a plaintiff driver could recover damages against a defendant driver for injuries that he received in a subsequent car accident. On July 21, 1964, 16-year-old William Pena was injured when the car he was a passenger in collided with a truck driven by Charles Bruckman and owned by Armored Motors Services. Nearly 1 year later, on June 11, 1965, Pena was injured in another car collision. As a result of the second collision, Pena aggravated the injuries that he sustained in the first collision. Subsequently, on June 25, 1965, Pena, through his mother as his next friend, or representative, sued Bruckman in district court of the city and county of Denver for negligence to recover for his injuries. In the action, Pena argued that Bruckman was responsible for both the injuries suffered in the original collision and the aggravation of those injuries in the subsequent collision. The case proceeded to trial, and the jury was instructed that if Pena had a subsequent injury that aggravated his injuries received in the original collision, Pena could recover damages for both injuries. In addition, the jury was instructed that it was to apportion the amount of damages between the original collision and the subsequent injury, if possible. Further, the jury was instructed that if it couldn't apportion the damages, Bruckman would be liable for all of Pena's injuries. The jury found in favor of Pena for $50,000, without apportioning the damages between the original collision and subsequent injury. Bruckman appealed to the Colorado Court of Appeals.